So we're about ready to get started. So I'm going to pass it over to your host, Sarah Hillier, Director of Estate Solutions. Take it away, Sarah.
Thanks so much, Carrie. Appreciate you. Here we have a quick agenda, and we're thrilled to have everyone here today to go over the important topic of estate planning. And this is a quick overview of what we're going to be covering today. So just real quick, a little bit about me. I am the Director of Estate Solutions at ClearEstate, and I do have many years of experience in estate planning and estate settlement. And my whole goal is always really ultimately to make these topics more approachable for folks, to help simplify things, and to really provide practical guidance for people. In case you don't already know about ClearEstate, this is just a little bit about us. Essentially, we're a one-stop shop for all things estate planning and estate settlement. And our goal is really to provide the right amount of support needed and desired for the circumstances. We do so using a platform that we've created to help make the processes super efficient, but we combine that with a team of subject matter experts to actually support what's needed to be done. And I do want to clarify again that we help folks to plan their estate, but we also help folks to actually execute the estate when that time comes. So today, our learning outcomes is really, we're going to talk about building an effective estate plan that is going to ultimately lessen the burden on your loved ones, and where you can get help for that. Now, the basics. What's an estate plan and why do you need one? So first and foremost, let's define what an estate plan actually is. What are we referring to when we say we need to do some estate planning for you? Really, it's all encompassing. Any arrangements for what is actually going to happen with your assets when you pass away. Okay, that could mean, a specific asset. It could be in general terms, but really it's all encompassing. What's actually what are the plans or lack of plans sometimes for what's going to happen when you pass away. Now, the documents that are involved and which are super important to have as part of your estate plan are ultimately your will. And I put here like legally executed, because it's so important that you not just create your will, but that you actually make sure that you've legally executed it. And we'll talk a little bit more in detail about that in a minute. Your will is, a core document where you dictate a number of things. However, generally speaking, what we're looking at is, who is going to represent your estate. So you'd appoint an executor in your will, and who is going to receive your assets after you pass away. It also typically would include some type of contingencies, like, if this person has passed away before me, then, this person gets it. But ultimately, that's the goal of a will, is to actually dictate who you want to receive your assets. Your power of attorney, there's two types. There's your power of attorney for property and your power of attorney for personal care. These documents are also extremely important. And sometimes they're overlooked, but they really are important, because these dictate who is going to have the authority over your assets for your power of attorney for property, and for personal care, who's going to have authority over you as a person in your healthcare needs and decisions if you were to become incapacitated and could no longer make decisions for yourself. So these documents are intended to make things, to have things occur as you intend if something were to happen to you. So you can include specific instructions in these documents or general guidelines. However, the important thing is that you actually appoint a representative to actually take care of things for you if something were to happen to you. Now, the other document here that I've put that not everybody has is healthcare directives. Sometimes healthcare instructions are included directly in your power of attorney for personal care. Sometimes you create a separate document, but essentially healthcare directives would go into further detail about what you would want to have happen in terms of medical care. Particularly, lots of people include detailed instructions on end of life care if they have particular wishes with respect to that. Now, a living trust, really, this is a specific type of trust that you could establish during your lifetime for various purposes. We're not going to get into detail on that today. It's a little bit of an advanced estate planning strategy. However, it is a type of document that may be included in your estate plan. So I did want to note it here. The other thing here is that's important to understand is really like why are we creating your estate plan? Why are we looking at this, right? And at the end of the day, the goal is to develop efficiencies and savings and actually customize the plan based on your circumstances and your family circumstances and what's important to you. And I'll add here too that you're trying to accomplish simplicity for your loved ones, and you're trying to ensure that your intentions are going to actually effectively be carried out. And I think what's important to note is that a lot of folks don't realize how complicated things can actually be with the lack of a plan. Not just a will, but also an overall comprehensive estate plan. Now, I'm going to dive right into the estate planning process. We're gonna work our way through it. I'm gonna try to give some specific examples. You may find here that if you had questions, this will help answer some of your questions, or it may generate more questions. In which case, we welcome you to ask us those questions. But overall, there's 8 steps in the process, the way I see it. So I'm going to go into detail on each step for you. So step number 1, and there's a very good reason why I put this as the first step, and it's because you want to actually look for help early. And the reason being, if you don't seek professional guidance early, you may actually go far along a path that you don't need to do because it doesn't apply to you, or maybe it applies to you, but it's not important to you, right? So I really encourage people to definitely seek professional guidance and consider doing that early on in the process. You want to consider specialists. And when I say specialists, I really mean professionals that actually spend the majority, or maybe even hopefully all of their time working in estate planning and estate settlement, because those are the folks that can really provide you with sound guidance. Okay, the lots of folks say, I got my lawyer to do my documents, and that's fine and good, but you actually may want to think about whether or not that lawyer actually specializes in estate planning, because there's many lawyers who do wills, but they don't actually specialize in it. They kind of just do it, they dabble in it, they do it on the side, which may be perfectly fine and good, but you may actually be better served by someone who specializes in it. Okay. You do absolutely want to make informed decisions. And I say that to mean, you need information and guidance in order to understand what applies to you and what actually should go in your estate plan, right? It's absolutely critical. You don't want to just, do things as others do, which brings me to my first don't, which is don't take advice, please, from just anyone. I'll give you an example that I hear of all the time. And it's when, so-and-so down the street, he told me he did this, and so I want to do that. And I just, it could very well be that he's done something really great, and it's also something that will benefit you, but it could not be, because his circumstances may be different from yours, right? And this is kind of on a similar theme. Let's not apply things broadly or out of context. So, when we're getting guidance on things, again, it all comes down to, does it actually apply to you in your specific circumstances? And sometimes it does, sometimes it doesn't, and we need to be careful to actually put things in the right context. This is a big one too, and I find when I talk to people about estate planning, the biggest reason why they never actually complete their estate plan is because it was information overload and they got overwhelmed, and they, maybe didn't mean to give up, but they put it on the back burner, and therefore they don't have an effective estate plan in place, and they know they still want to and know they should, but they've been overwhelmed with information and decision making, and they've given up. And I think, breaking the estate planning process down into steps, which is something we do at ClearEstate, is something that really helps people to move through the process and complete the process. So step 2, compile all pertinent info and documents. This is really important, and I think is a very often overlooked step. So I would say, your dues here are really to actually be thorough and have the patience to be thorough. And when we say pertinent information and documentation, we mean like everything that defines you, your circumstances, even your family's circumstances or your loved one's circumstances, and all the documents that identify you, and or your existing wills and power of attorney documents if you have them. You're going through everything with a fine-tooth comb, so you need to be thorough so that you actually collect and compile everything. Okay, and you're doing this for 2 purposes. One is to actually consider everything. So when I say think practically here, I mean you're going to actually think about all the logistical steps that are going to need to be dealt with when that time comes, which is going to help you to understand what should actually go in your estate plan, right? What specific instructions do you need to include based on everything about you, right? Also, the second purpose of doing this is access. You're collecting, compiling everything in order to make it easier for your loved ones when the time comes to actually know where to get all the information they need to actually administer your estate. And actually, this is critical because lots of folks actually are not sure if they've had a loved one pass away. They're not sure if they've ever done any estate planning. They're not sure if they ever executed a will. And unfortunately, there's not a lot of ways to be completely certain whether someone did or didn't have a will unless you actually have it in your possession, right? So consider how people are actually going to access your information and your documents is critical. And I think too, if it can't be found, then it's as if it doesn't exist, right? So your careful planning may go to waste if your documents and information can't be accessed. Don'ts. Okay. Definitely don't forget about sentimental value. And I think this is important because oftentimes in a traditional estate planning process, there's a heavy focus on monetary value, right? We think about, okay, what do I actually own? How much is it worth? What's in my bank account or my investment account? And very little time is actually spent on items that have sentimental value. And maybe they have both. Maybe there's items that have monetary value and sentimental value, but sentimental value is commonly overlooked. And by that, I mean, if you were to pass away, and you think about what items might be important to your family members, they might not think about your bank account first, right? They might actually think about something that was important to you, like a collection you may have, or something that holds significance for them because it was a gift they gave you, or different things like that, heirlooms that have been passed down from generations. Things like this are often overlooked in estate plans, and they're very, very important. Don't assume that it will be dealt with and everything's going to work out just fine, please, because this is where things can really fall apart. Is that I think from a planning perspective, we often think, oh, okay, that's like pretty simple. It's going to be fine. But I think we have to be careful not to assume that, because that's actually how things can go drastically wrong. So, for example, your will just states that your personal effects are going to be divided between all your family, all your children, is common instructions I see in wills. And there's no further instruction to say what will happen if they disagree, right? So now you've accomplished your goal of dividing your assets equally, but you actually haven't you actually haven't given them a practical way to move through it, right? So that's an example that I would give for that. And the other thing is, which goes back to being thorough, really, is really you do want to make sure you leave no stone unturned. So don't leave any stone unturned. It's really critical that all the information that's needed is compiled somewhere. Again, both for you to have a clear view of what your estate plan needs, but also so that your executor will have what they need when that time comes. Okay. I would say be obnoxiously thorough. Okay, so the next step really is to consider your goals and your beneficiaries. And some quick do's and don'ts here is you need to focus on what's right for you. And when I say that, I mean your circumstances, your loved ones, and the specifics around that. And no one can tell you what your goals should be in relation to estate planning or in relation to your loved ones, right? For example, there's some folks who want to divide their estate equally between their children. It's quite common, right? But there's other folks who actually want to divide their estate in a way that is not equal because they're taking into consideration maybe gifts that they've given their children during their lifetime. Maybe they're taking into consideration their children's personal circumstances and their actual needs in terms of financial needs. Maybe there's other considerations there. Neither of these strategies is right or wrong. It's just about what actually makes sense for you and your family. Think specifically. So this is important because lots of times when we're doing estate planning, we just everything is kind of like in broad strokes, and an effective estate plan really needs to dig a little bit deeper. So when we talk about your circumstances, you actually have to think about, okay, what is my family? What is the dynamic of my family, right? Do I have only biological children? Do I have no children? Do I have children that I'm a step parent of? Is my first marriage, second marriage, right? Like, is it a blended family? And you need to think about how you're accounting for, different bloodlines, etc. Right? Do you have beneficiaries who have any type of special needs? Like, are there folks with disabilities? Are there relationships that you want to recognize that aren't legally recognized? Like if somebody has a very long-term partner, like all of those things that actually apply to you and your loved ones specifically need to be mapped out so you can think about how that impacts your goals. Prioritize your goals is the next one. And really, when I say prioritize your goals, part of that is because you may have to evaluate what strategies to implement based on what's most important to you. Because in most scenarios, you can't accomplish all of the things, right? So you have to decide, okay, is it more important to me to effect tax savings? Or is it more important to me to perhaps, protect an inheritance that's going to a loved one, right? And sometimes those goals can be accomplished. It can both be accomplished, but sometimes they compete with each other. So it's important to actually look through and prioritize your goals. This is really important. Don't let someone else dictate anything, right, about your estate plan, right? If you are a couple, you should certainly communicate about your plan, especially as many couples do their estate planning together. Of course, some couples decide not to, but either way, there should be some acknowledgement there based on obligations. But when I say let someone else dictate matters, I actually even mean professionals. So, and what I mean by that is sometimes when we're doing estate planning, because professionals, particularly because we see so many things go wrong, we are very protective in terms of how we think about things. So we're always thinking like, how do you mitigate the risk of this? But if that risk is not that important to you, then it might be okay to proceed in a certain direction, right? Even though a professional is saying, you should or shouldn't do this. So that's what I mean when I say don't let someone else dictate matters, not your kids, not your spouse, although with the caveat of you should probably communicate about your plan together. Not any professional. You should make decisions, that feel right for you. Don't overlook a loved one's circumstances. And here there could be lots of examples that actually fit into this category. I mentioned, for example, if you have a beneficiary with a disability, you actually need to think carefully about that in your estate plan, because you have to think about, okay, what potentially, is the estate funds intended to potentially support them in the future, right? Do they have access to government benefits that you don't want to necessarily interfere with, right? And are there ways to structure your planning around that? Is there a circumstance where you're worried about them, right? Like, is something going on with them that concerns you? Like, all of that has to be factored into how you plan your estate. And this one is important too. Don't assume everyone will understand. And I'll give you a very specific example about this. When you're doing your plan and you're setting out your intentions, it's really important that you're so specific that it's not that there can be no misunderstanding about what you mean, right? And this is why the vast majority of wills come with a lot of like legal jargon to be specific. It does make them difficult to read. At times they're necessary, at times they're excessive. But for example, if you've made a list of all the things that you want to give to various family members, like from your jewelry collection, and you've said that Carrie is going to get my gold ring with the 3 surrounding diamonds. And then you have another item where you say, Carrie's going to get my gold ring. Or sorry, someone else is going to get my gold. Sarah's going to get my gold ring. Which ring did you mean, right? So this is what I mean when I say, like, don't just assume that whatever you've laid out, everyone's going to understand. Look at it from the perspective of, when that time comes, when we're looking through these instructions and intentions, will it actually be clear? So that's really important as well. Choose your representatives, of course. This is important. So we're talking about who's going to act as your executor, who's the person who's going to be responsible for your estate settlement, and who is going to be your power of attorney for property, your power of attorney for personal care, as well as who you're going to point to as backups for those people. So there should be alternates, at least one, but even two alternates would be ideal. Obviously, you do want to choose wisely. Like, this is an incredibly important responsibility. It's an honor actually to act as someone's executor or power of attorney, but it's also a significant burden in that there's liability, there's lots of time spent, often there's stress and strain. And it's a lot of work, right? You do want to think about, is your executor even local to you, right? Are they practically speaking going to be able to drop whatever they're doing and attend to what's needed in your estate settlement, right? Do they have the time? Like, are they busy with their careers or their families? Are they older than you so that it's unlikely they'll actually survive you, right? Are you thinking that everything will are you just sort of you're just going with what you had before? Like, you have to be careful to really think through, and that's why I say be practical. And I say consider emotions too, because you want to be practical and you want to think about who's the best suited to actually take on this role. But also, you do want to think a bit about, your family dynamics and how that's all going to play out. And I'll say that's not necessarily, your only consideration, but I think it does need to be part of the thought process, because it brings me to my next point, which is you want to inform them that you've appointed them. I can't tell you how many times folks actually don't even know they're appointed. And I think it's important that they not only know that they're appointed, but also that they actually have some bit of understanding of what's involved. What are they actually going to have to do, right? Well, they're going to be, if they're your executor, they're going to be responsible for, collecting, safeguarding your assets, assessing what your just debts and liabilities are, making arrangements to pay those, and ultimately, distributing your estate, while accounting to beneficiaries, right? That's like a quick summary, but they should know, okay, what does each step, entail, have some idea of it, okay? What I would say don't do is just follow the status quo. Lots of folks, and this is not necessarily wrong, it may make perfect sense for you and your family, but lots of folks who have children, they'll appoint the eldest as the executor, and maybe that's makes perfect sense, but maybe it doesn't. Maybe the eldest is actually not the best suited to take on the role. Maybe they're not the one in the family who tends to do the administrative organizing, right? Maybe they're not local to you, right? Particularly if they're out of your province or out of the country, things can get very complicated. So it's not necessarily a good idea to have someone who is not local to you. So you really do want to think through this carefully. And you don't want to underestimate the power of your power of attorneys. Okay, so lots of people do their power of attorney documents as kind of almost like a bit of an afterthought. Like, okay, I made my will. It's got everything I want in it. It's a perfect estate plan or perfect piece of my estate plan. Now, who's going to be my power of attorney? Well, okay, I pick this kid as my executor, so I'm going to pick my other kid as power of attorney. But the reality is, if you were to become incapacitated and your power of attorney, were to mishandle things, either, hopefully not intentionally, but maybe, perhaps by no fault of their own, maybe they've overlooked something, made a mistake on, your tax situation or whatever the case may be, they could potentially destroy your estate plan before you, or your will, your intentions in your will, before it even comes time to think about that, right? So it's really important that a power of attorney is chosen wisely. And unfortunately, when power of attorneys are invoked, I would say there's it becomes a much higher likelihood that there's going to be family squabbling because, people start questioning the activities of the power of attorney. So that is really important and shouldn't be overlooked. Brings me to my next point, which is don't assume everyone will get along, because of course, oftentimes we do think that, and we hope for the best, and even in the best of scenarios, like everyone, does get along. It doesn't always end up that way, right? And we need to be mindful of that and be aware of that. And sometimes if we're talking about, children, then, when their parents are gone, this can be kind of like tensions start to rise and different things come out that you haven't seen yet, right? If you do have, siblings or whomever else you're accounting for in your estate, you need to think about how is your estate plan going to be carried out, and how, what impact is going to have on the relationships that everyone has with each other. Because hopefully you can set up your plan in such a way that you're lessening the strain on the parties involved and lessening, the potential conflict that there may be between them. Okay. The next piece here is a big one. So the next step is really talking about any strategies that you're going to implement for efficiencies, savings, and potentially protections that you might want to, create for your loved ones. Now, what you do definitely want to do is consider probate savings. So I'm going to go into a bit of detail on this for anybody who's not aware. When we refer to probate, this is the legal process that an executor or a state representative, if there's no will go through with the court to verify their role as the estate representative and validate a will if there is a will. And it's a time-consuming process, a legal process. It's not easy to navigate, and it also comes with probate fees, which in Ontario are 1.5% of the value of the estate as of date of death, above $50,000. Okay, so you take the inventory of your assets, and you can subtract mortgages, but other than that, you can't subtract others when you're calculating probate fees. So it's 1.5%. And when you're doing your estate planning, this is often a big piece, is thinking about, okay, are there ways that I can, effectively save on probate? And often, because this gets asked a lot, I do want to say, like, the practical steps of applying for probate. It is a legal process. In Ontario, in Canadian jurisdictions, you technically don't need a lawyer to complete that process. However, because it's somewhat challenging to navigate, depending on the circumstances, most people do seek out professional guidance, right? This is something ClearEstate absolutely supports families with. We will prepare and file probate applications when they're needed, as well as help carry out other steps in the estate settlement. So thinking about, probate savings potentially and how you could do that, there's a few ways. I'm not going to go into detail today. I think that will be for a separate presentation. But there are ways to strategize around probate savings. And one of those ways that most people are aware of is, using beneficiary designation. So I'm going to touch on that briefly. And that is where you have a type of account, like a registered account or a life insurance policy, where you can actually name specific beneficiaries. This is definitely something that is done quite commonly, but should be reviewed carefully, because essentially when you create a beneficiary designation, you're removing to a person directly, you're removing that asset from your estate. So that just has to be mapped out carefully. I'm going to say here, you should consider trust planning. Most people should consider whether or not a trust applies to them. And there are, like I mentioned earlier, living trusts, but there are also testamentary trusts, which are trusts you create during your in your will that take effect after you pass away. And there's various purposes you might create a trust like that. I'll mention a few today and can go into more detail in a separate presentation. But if you're thinking about protection, so for example, a beneficiary, that you don't want to just have access to a large sum of money, right? You might create a trust for protective purposes, to pay out the funds in installments over time. Or you're thinking about creditor protection, right? If a beneficiary has their own business, or is likely to be sued because of their profession or things like that, you might want to do it for creditor protection reasons. Marital breakdown protection is another big one. If you're concerned that there may be a marital breakdown with a beneficiary and you don't want them to be obligated to or have that asset be at risk to being split, then you want to think about that as well. So some of the reasons, but there's others. Commonly, if you have minor beneficiaries, those under the age of majority, trust planning is done quite commonly for them. So lots of different reasons, and all of that should be factored in. Okay, now this goes back to things with sentimental value, but also when you're talking about strategies and planning, right? Don't just think about monetary savings. Think about time savings. Think about preventing strain and stress. And sometimes those goals might compete with each other, right? But the important thing is to think about what makes sense for you, right? So, for example, if you created some probate savings, but then practically and logistically, my next point, you've left your estate insolvent, meaning there's no cash in your estate to actually cover its liabilities, you have to be careful about that, right? Your estate will almost certainly need some cash when you look at estate expenses. I believe we have another whole presentation already done on that. And don't forget about liabilities, right? What are all the expenses going to be in your estate, right? What do you expect as expenses, and what have you not necessarily thought of in terms of expenses, right? Your funeral expenses alone can cost a potentially significant amount of money, right? Right now, there's a Canada death benefit that maxes out at $2,500, but which is intended to support the funeral expenses. However, most funerals cost thousands of dollars, right, depending on how it's done. So all of those things need to be factored in and thought about. Next step, understand how everything fits together. This is really important because you need to think about right now, and a lot about right now, and lots of times people don't. People think, oh, when I pass away, the situation is going to be this. And if I had a crystal ball to tell you exactly when you're going to pass away, I'd be the best estate planner ever. But the reality is, you don't know. None of us know, right? And so don't think too much into the future. Think a little bit about the future and what is potentially going to be the circumstances in the future, but you need to actually plan for your circumstances right now, okay? Mapping it all out is crucial to actually, understanding and knowing what's appropriate. So if you can get a clear visual, okay, what is my distribution actually going to look like, right? Like, I've done these beneficiary designations, I've created this trust, I have these liabilities. You need to actually map everything out to look at it as a whole, okay? Don't do anything in isolation, right? So we're thinking about estate planning holistically. Don't just solve one problem and create others, right? And here, this one is really important. Don't fail to align moral and legal obligations. And by that, I mean, if you've done something in your plan that you've communicated to your family members, but not actually laid out instructions for in your plan, then you actually haven't really done it in your plan, if that makes sense, right? So let's say, for example, you've said to your executor, I want so-and-so to receive my coin collection, right? But you haven't actually put that in your will, and you just are giving them a moral obligation to actually give that coin collection to that person. You have not given them a legal obligation to give that coin collection to that person, and maybe that's okay with you, but maybe it's not, right? So you do want to align moral and legal obligations. Overlooking legislation and obligations, this is crucial. So legislation could mean a number of things. The number one thing that I see people overlook is common law versus legally married spouses. They're not necessarily treated equally depending on the jurisdiction you're in. In Ontario, for example, common law spouses, while you would, file tax returns together, they do not have the same rights as a legally married spouse if you were to pass away. And I think that's really important because, in a modern world, not everyone, some people have relationships and they do intend for their common law spouse to receive their inheritance, but they haven't actually planned around that, which means that when that time comes, there can be some really unexpected outcomes for their common law spouse, such as not having any entitlement to assets. Okay, so it's really important that that's not overlooked. And on the flip side, if you're married, you have legal obligations to your spouse that should be considered as part of your estate plan. So if you're legally married, and don't want your spouse to have anything, that actually needs to be part of your plan. Can you actually do that? Will they agree for you to do that? Or do they want to, consider what they're entitled to under the law? So those are really important to look at. Preparing your actual estate planning documents, it's key that you actually legally execute your wills and powers of attorney and supplementary documents. So by legally execute, I mean, for example, in Ontario, in order for your will to be legally valid, if it's typed out, it needs to have two witnesses and the witnesses should not be anyone that actually is in your will. So ideally, a neutral third party are your witnesses for your wills and your POAs. And supplementary documents in Ontario, when your executor goes to file for probate, they're also required to produce an affidavit of execution, which basically is an additional sort of covering page to the will that should be notarized by the signature of one witness should be notarized on that document. And that additional document is often overlooked, but it's really important because years later, if you don't have it, you might not have access to that witness to get it done at that time, right? Really important. Ensure they will be accessible, of course. Lots of people very wisely put their wills in their safety deposit box, right? So that it'll be safe. But then they don't tell anybody that they have a safety deposit box or where the safety deposit box is located. And in which case it's possible it won't be found. Even if it is known that it's there, it could be difficult to access. So, because the banks typically do this thing where they require probate in order to access it, but you can't get probate until you get the original will. So it's a strange situation that causes a bit of stress and strain. So you need to ensure that people actually know where to get the documents and where to go for them. I mentioned this already. Don't use the parties you've named in your will as witnesses, and don't forget the second witness, which is unfortunately a circumstance that I see all the time when people prepare their wills themselves. They don't ever get it properly witnessed by two parties, and so it's not valid. If it's not valid, then your instructions are going to waste, right? I've also seen a lot of people who mark up the documents that they've already executed, which is not actually valid either, and then there's surprises later when it turns out that wasn't effective, right? Final step is communicate your plan to your loved ones and revisit, right? You want to actually maybe have a family meeting, right? Maybe get things out in the open, and maybe do this before you finalize things, if your family dynamic allows for it, right? It's a good idea, I think, to inform your executor and your powers of attorney of their roles. Like I said earlier, they should know what they're getting themselves into. And revisit with any event that arises, or at least every 3 years. And when we say any event, like any change in circumstances, like you've had a child, your marital status, you've gotten married or divorced, maybe you've had a grandchild, or something else significant has happened to you. Maybe you've received an inheritance. You should look at your own estate planning if you've received an inheritance, right? Maybe something significant has changed with your assets. That's going to change your estate value at the end of the day. So all of those things are important. Don't forget to make sure that your plan is aligned. And even if that just means, okay, quick check, okay, this just happened, quick check, let me pull up my will, take a look at it. Is it still effective? Did we do enough contingency planning in the document that we're good still, right? Don't overlook jurisdiction. So even from province to province, the rules vary. So if you've moved out of your province, you really do need to relook at everything. And don't think of it as taboo to talk about. I think that's important as well. So, I just want to talk real quick a little bit about how ClearEstate supports people with estate planning. Essentially, our whole goal is to make the whole thing as easy as possible for you and go through a step-by-step process to actually, fully execute your documents in a way that makes sense for you and maintain that, information and update that information as needed, as well as have your loved ones have access to what they need when that time comes. Okay. A little bit more detail on, the actual steps we take is outlined here. It's, similar to the steps and the process that I outlined in more detail. This is, the actual practical ways that we go through the process with you and the order in which we do so. And of course, our platform is, a secure digital vault, essentially, in that it's, it's unique to you. It's fully secure, and your information is safeguarded, and you can access it at any time. And then, of course, when the time comes, your loved ones can access it. Now, I do want to talk real quick about our free will. So we know that it's really important that everyone has a will, okay? And we know that over half of Canadians actually don't have one, and even the ones who do, it hasn't been updated. It's out of date. So we really want to help with this, and so we've created an easy way for folks to get their will generated on our website. So you can actually go to the website that's listed here and create your own will in just a few minutes, and then follow the instructions to ensure it's legally executed to actually get that will in place for you. Okay. If you are thinking about, additional guidance, of course, we do offer additional guidance in doing a complete plan. But we'd like to offer the wills for free, just to help everyone actually get those in place. Okay. So key takeaways here: you need an effective estate plan. You need to map it out. You need to plan carefully, and you need to compile everything. Okay. You need to get the right help and actually document what your intentions are, and execute them legally. Okay. And then you need to communicate and revisit your plan over time. And it's important that you, I think, are kind of almost like this is something we help people with, but hold yourself accountable, and we'll help hold you accountable to make sure that you are looking at everything you need to look at, and that your plan makes good sense, especially as your circumstances may change, right? So as I believe I mentioned, we offer free consultations to support you in your estate planning questions, and consider how ClearEstate can help you further in getting an effective plan done. And I think with that, we're going to turn it over to Carrie for a few questions now.
Hi, Sarah. Thank you so much for that. That was so informative. We got a ton of questions. We only have about 10 minutes left in our allotted time, but let's see how many questions we can get answered today. First one, should I add one of my grown children as a joint bank account holder to my bank account?
Every time, right, Carrie? We get that question every time. So the answer really is it depends. And the reason it depends is because it goes back to what are your goals. Okay. So if your goal is, and also you need to clearly lay out your goal, right? So if you have an adult child and you add them to on a bank account, there's a legal presumption under the law that you've done that for convenience, right? That they're going to help you to pay bills, et cetera, because it's between an individual and an adult child. So because of that legal presumption, technically that account should still form part of your estate and still be distributed as per your will, right? If you actually want the account to be joint with right of survivorship, then you need to establish it that way. And unfortunately, banks are not always the best at making sure there's proper documentation to dictate how you want that account to go. So you're leaving it up in the air how the account's going to be treated. Now, if you do want it to be joint with right of survivorship, and you want that adult child to just have the account when you pass away, that's fine and good. But keep in mind, you've removed it from your estate now, right? It's theirs. And they don't have a legal obligation to use it to pay your bills, expenses, or to divide it between others, which could be your intention. Okay, so I know that was a long answer, but it's important, I think, that you understand the context there before you do anything like jointing an account.
Great, thanks, Sarah. Next question. Once you have a will, do you need to retain a lawyer so that the lawyer will have the will available when something happens? What are the other common options so that your loved ones can access your will after you're gone? I believe you touched on this before.
I did, yeah, and that's a great question. And I think like the simplest answer is like tell your loved ones, right? Like communicate to your loved ones. Keep your will in a safe place, and that can mean different things for different people. But preferably it's somewhere safe, and maybe like some people have fireproof safes in their home, etc. Some people do store it with a lawyer. ClearEstate, we do offer to store it for some of our packages. And but most importantly, communicate where it can be found to your loved ones. You don't need to have a lawyer hold your original will in most jurisdictions.
Thank you. Next question. Can a simple holographic will be challenged?
Great question. So quick definition, holographic will is a will that you've done entirely in your own handwriting. It doesn't have the requirement for a witness, unlike a will that is typed. And for that reason, it is more commonly challenged, I would say, than a will that is witnessed, because folks who don't include witnesses, then, it just becomes a little bit harder as to what was the person's capacity when they signed the document. The reality is any will can be challenged, right? But yes, it does leave open the door a bit to I would say more scrutiny.
Great, thank you. Are internationally drafted wills valid in Canada?
Great question. So it depends. Again, that seems to be the common theme of the answers, but it depends on how exactly the will was executed. So the laws vary significantly sometimes from jurisdiction to jurisdiction, including the laws around what constitutes a legally valid will, and whether you have the testamentary freedom to divide your assets as you see fit. What happens if you have different family members that it depends on does the country you've made the will in, does it have the same requirements or not? Like, it can get quite messy. What you actually should consider is, do I need a separate will, one for Canada and one for the other jurisdiction? And the answer to that is, again, it depends on the specific circumstances. What assets are there? Are they immovable assets like real property, or are they movable assets like possessions and things like that? So you need to evaluate whether or not, and sometimes do an entirely other will to make sure that they're going to be effective in both jurisdictions.
Great. Next question. If my child was a minor when my will was made, should it be revised now that she is an adult? So in other words, how often should a will be revisited?
Mm-hmm. Great question. So like I said, general guideline is anytime circumstances change. And I do consider a child becoming an adult a change of circumstances, but it depends on what instructions you had in your will, right? So revisit, it doesn't necessarily mean you have to make changes depending on what you've outlined, right? So for example, if your will said that, the funds are going to be held in trust until my child is the age of majority, right? The age of majority in Ontario is 18. So maybe they've turned 18, and maybe you're looking at your will and you're saying, they're only 18, right? Maybe it's not old enough for them to get a lump sum if something were to happen to me right away, right? So maybe you do want to make a change to your will and include some type of testamentary trust to hold the funds for a period of time till maybe they turn 25 or turn 30. Like, only you know what the right answer is, but there's definitely options that you should think about if your child is now an adult.
Thanks. We have time for a couple more. Is it better to leave real estate in a will or make them, the beneficiary, a co-owner?
Yeah. Okay. So this actually goes a little bit back to the same question around joint bank accounts. Similarly, If you want to make them joint owner, and typically when people are doing that for estate planning purposes, or in the context of this question, anyway, they would be referring to, joint with right of survivorship. And that actually does accomplish some estate planning efficiencies and goals. For example, you've avoided probate on that asset. Anyway, there may be other assets that require probate, but if it's joint with right of survivorship, you're going to be able to avoid the probate process, and the property goes to the surviving owner, right? However, if you add somebody to title, there's tax considerations, right? You're actually disposing of a portion of the property and transferring it to them, right? So there could be potentially capital gains, depending on if it's your principal residence or not. Then moving forward from the point where you've added them to title, there's additional capital gains considerations for you and them. So now you have to think about that. Are you creating additional tax that wouldn't otherwise be payable during your lifetime? If they can't access the principal residence for their exemption for their share, right? And then when you pass away, is that truly your intention? You want only them to receive the property. They won't have an obligation to use it towards any instructions in your will, right? So again, like the answer, it very much depends. I think most estate, professionals would caution to be very careful with jointing assets, because the other thing that we've discovered is that it also means that asset is potentially accessible to their creditors, right? Which could quickly become quite a nightmare if you're still living in your home and all of a sudden, there's creditors knocking on your door.
Okay, and we've got time for maybe just one more, Sarah.
Okay.
Is it better to have a family member be your executor or a third party? And would it cost your estate the same amount?
That is a fantastic question. So again, it depends. That's always my answer. But the reality is, it's better to hire a professional from the perspective of, now you're guaranteeing that things are going to be handled in such a way that you have experience, you have expertise, you have all of that you're guaranteeing is involved, right? Are you giving up a bit of control from your family members? Potentially yes, right? So you're weighing those things out. The reality is that when it comes to costs, a professional or a lay executor, the guideline in Ontario is 5% of the value of the estate asset. Okay. That's what compensation can be charged, whether it's a loved one, trusted person in your network, or a professional. Okay. Professionals typically charge less than 5%. When people are doing it personally, ClearEstate also can act as your professional executor as well. So it's important to know that, and think about that as you're doing your estate plan. That we're happy to discuss that with you if it makes sense for you and your circumstances. But I think generally speaking, professional executors can actually help to, particularly if you choose the professional wisely, they can help to lessen the overall expenses in your estate if you've planned it in advance, right? ClearEstate, we strive to do that, and our costs are typically about 1/3 of what other service providers in the space are charging. But like I said, you are giving a bit of control up for your family, but then you're alleviating significant burden, right? And making sure everything's basically, done for them.